Have you received an email or text from someone who wants to help you with your Social Security disability claim? Beware. Lawyers are not allowed to contact you first to represent you. These companies are not law firms. The Social Security Administration allows non-lawyers to represent claimants. These companies are also usually out of state. Why hire an out-of-state paralegal when you can hire a local lawyer for the same fee? At our firm, my paralegal meets with the client, discusses the case in depth, reviews and requests all their previous medical history, and I personally read all those medical records, go through that evidence, and prepare a brief prior to the hearing. And I also meet with the client personally to prepare them for their hearing testimony. All those things are necessary in every single case. It's hard for me to understand how somebody can show up at the hearing, never having talked to the client, never meeting the client, and not preparing the client until a few minutes before the hearing and expect to win the case. Also, not all lawyers, and certainly not all paralegals, submit briefs prior to the hearing. I've had numerous judges tell me they appreciate the brief and they certainly have read the brief prior to the hearing. That is very important. It's a chance for the judge to see the case in a very condensed way, because we have several, sometimes thousands of pages of medical records in these cases. A 1 or 2 page brief to the judge narrows the issues and makes it more likely, in my opinion, that the judge is going to actually decide the case in your favor. It's very risky to go to these hearings without an attorney. I would not recommend going to a hearing with a paralegal or a non-lawyer, especially when an experienced Social Security lawyer, like myself, charges the same fee. Call us today for a free consultation.
If you're hurt and can't work, call 300-HURT.